but I think we got the better of the argument. Exactly whether he enjoins the entire statute or just part of it, I think he could go either way. Obviously, I would prefer injunction against the entire statute, but that's another of the factors he has to consider.
Again, that's Attorney Thomas Maag talking about what he is interpreting from the judge in yesterday's Vagueness hearing on whether or not Illinois' gun and magazine ban is constitutionally unvague. Back at it, Springfield's Morning News. I'm Greg Bishop on 92.7 WMAY, Springfield's News and Talk. We'll hear a lot more of what Mag had to say here, but again, to revisit, if you missed the readout of the live posts on X, formerly known as Twitter, I would encourage you to go check out my Twitter page. Just search Bishop on Air, and we can connect that way. One thing I do want to note is, while this was a vagueness argument, the judge, time and again, especially in the latter part of the 2-hour hearing, he discussed how, yes, this is vagueness, and that's what the challenge is, but Judge Stephen McGlynn said that the court is determining if the law implicates Second Amendment rights that the Supreme Court of the United States says is not a second-class right. And he says that there are widely held restrictions in law that don't pass that test. He notes that other districts have different opinions, but he says this is about the Second Amendment. And he argued that the state seems to have let a broad statute through and says, let's clean it up later. He says you got to thread that needle. Is it too hot? Is it too cold? Or is it just right? So the judge kind of wrapped up some of the arguments yesterday with that. But Thomas Maag, again, he laid out what he feels the judge had to say and how he sees a prediction of how this might actually play out whenever the judge ultimately does rule.
But I think we got the better of the argument. Exactly whether he enjoins the entire statute or just part of it, I think he could go either way. Obviously, I would prefer injunction against the entire statute, but that's another of the factors he has to consider.
But what does that look like exactly? How is that outcome going to come together? If it's going to be partial or if it's going to be full? Is that something that ultimately is going to be clear? Right.
That is absolutely correct. We're not asking the court to predict how it might rule in the future, which is what a preliminary injunction is. We're saying we win, and the facts and the law are on our side. There is no genuine issue of material fact in dispute. These statutes are, as a matter of law and a matter of fact, unconstitutionally vague for the reasons that we have argued.
So he says that this isn't about a preliminary injunction. This is about a summary judgment, meaning it could strike the law down entirely or strike out portions of the law. Practically, what does that mean? Here's Mag.
How it is supposed to work, and sometimes it doesn't work this way for whatever reason, is that if an injunction is issued against a given statute and the losing party wants to appeal it, they're supposed to apply to the trial court first to ask them to stay it on appeal, and then and only then, if that's denied, do you ask the appellate court or ultimately the Supreme Court. Sometimes appellate courts, sometimes the Supreme Court will simply jump in without giving the trial court a chance to rule, but how it's supposed to work is you make your arguments to the trial court first.
And, the chilling effect here.
Chilling effect, it's very simple. If you don't know what an AK type is or an AR type, you're going to steer away from what you're not sure about. For instance, an M1 Garand, same gas and bolt system as an AK. Millions of them legally owned in this country. Classic battle rifle of World War II. Is that legal in Illinois? Frankly, I don't know under this statute. I'd like to think it's legal. But can I say that it is, that it's not subject to registration? No, I can't say that.
So again, Thomas Maag, one of his arguments also was that the law has a chilling effect. And the state fired back and said, the chilling effect is only something considered for the First Amendment. And then McGlynn said the Second Amendment's not a second-class right. It's more from Maag.
What it would mean, let's assume hypothetically that the court did not strike the entire ban. It only banned the copy duplicate as opposed to the features test. What that would mean in plain English is you could remove the pistol grip from your AR-15, and you remove the flash suppressor / threaded barrel and make what we used to laugh and call a California compliant rifle, but be an Illinois compliant rifle. It would just kind of sort of be similar to an AR-15 or an AR-10 or whatever version you're dealing with.
So again, Maag saying if it goes the way of a narrow injunction against a portion of the law, it would be narrow. But what about that Fifth Amendment argument with the registry coming up?
The answer is yes. We intend to proceed with those. The state, just in the last week and a half, filed their paperwork, their description of their registration affidavit. So we now know exactly at this point what the state expects to be registered, but for the vagueness issues and what they're asking for. And therefore, we think it probably would have been technically premature to file that before October 1, October 2. But now that we know what the state is actually asking for, we expect to file those arguments in short order.
And the judge even mentioned, hey, that's open right now.
Absolutely.
There are people that are filing right now.
Right now.
That could be violating their own rights.
Personally, I would not register anything in October or November because the statute as written, assuming no court intervenes, provides registration through the end of this year. So there's really no reason to rush to register. If the statute is still in effect towards the end of the year, obviously the persons would have to decide what they want to do, remove the firearms from the state, register, do something else. But at least as far as October and November goes, I wouldn't register anything.
So again, Thomas Maag, the conversation I had with him after yesterday's court hearing.
Right.
That is absolute.
When are we going to see a ruling?
That is absolute.
It's a good question. Not sure when a ruling is going to be issued. Courts kind of move at their own pace. So looking back, though, at the hearing that happened earlier this year in the Southern District, Stephen McGlynn issued a ruling somewhat quickly. I mean, it was just a few weeks, really, if you think about it. But that was on a preliminary injunction. And I think what's important here is to note that this wasn't a preliminary injunction hearing. This was a summary judgment hearing, meaning on the merits of the law, on the merits of the argument. It's not whether or not the judge predicts how they could advance their merits. A preliminary injunction does. This is a summary judgment, meaning the judge could strike down the law entirely or portions of the law. Something else that's fascinating, I was the only media there. I didn't see any of the other media. And with the consequence of this particular case, it just begs the question as to where's the other media on this? Anyways, all right. It's all we've got here for that. Of course, we'll be tracking it more and more, and we will update you as soon as we get a ruling. So thanks for hanging out with us. It is a pleasure and an honor. I'm Greg Bishop. Follow me anywhere. Just search Bishop on